There's been a lot of comment made on the requirement to have an independent and impartial tribunal. This is very important because any sentence which is handed down by a tribunal that does not meet the test under Article 14 of the International Covenant will be considered to be unlawful, be it a period of imprisonment or a death sentence. If it has not been handed down by a tribunal that meets the requirements of independence and impartiality, it will be considered an unlawful act. There has been a lot of focus on the chairman of the tribunal being a participant. Whether it is a minor participant or not is quite irrelevant, but there's been a lot of discussion about the judge's participation in the People's Inquiry Commission. But what hasn't been discussed is the fact that under international law and under most systems of national law, it is inappropriate for a judge to be making preliminary rulings in a case and then sitting on the main trial, particularly when those preliminary rulings have entertained the merits of the case at hand. If a judge has sat on a bail application or a question of disclosure, he will have had to look into the merits of the case. He's then sitting on the main trial, having previously made a ruling on the merits of the case. That means that his impartiality, objectively, can be called into question. There are numerous cases in the European Court of Human Rights where that very issue has been raised, and it has been stated that it is improper for a judge to sit on pre-trial and trial matters. That is a question of impartiality. The question of independence arises from the manner of appointment of those judges and whether they are effectively independent from the executive. The comment has already been made as to the manner in which the government, through ministers and through public opinion, are impacting on the independence of the tribunal. It is almost impossible for the judges to act independently in such an environment when ministers are frequently setting timelines and setting decisions that will be made in terms of when a person will be charged, when a trial will start, and when the trial will finish. It will be very difficult for any mature system to be able to withhold that kind of pressure and act truly independently. One of the other speakers mentioned the rules of evidence. Now, I'm not going to cover that. John will be speaking more about the trial process, but it is of concern where there are none. When the domestic rules of evidence in what is considered to be an established judicial system are ignored, and they are left to the whim of the tribunal, with no ability, as we've already said, to challenge any ruling it makes. The kind of evidence in these types of cases is always very difficult to challenge. But when you have rules that allow for effectively trial by rumour, and that allows, not only allows, because the wording in the rules is that the tribunal shall take judicial notice of government reports. Now, most tribunals will all have a rule on taking judicial notice of a fact. But it's a matter that is subject to debate, where the defence has the opportunity to legitimately challenge the taking of judicial notice. And it certainly doesn't allow the party who's bringing the case to put before the tribunal its own reports and for the tribunal to take judicial notice thereof. One of the other speakers spoke about the presumption of innocence. This is one of the gravest concerns that we have. there are constant statements referring to these individuals as war criminals. There is constant statements that the men in the dock are responsible for 3 million deaths. Again, every statement of this kind is in breach of Article 14, Paragraph 2 of the International Covenant. The Tribunal, again, has ruled that the International Covenant is not a matter for them to consider. They are only required to consider the Act. But the important decision that has come out recently is the decision of the United Nations Working Group on Arbitrary Detention. This is a petition that we filed on behalf of the Jamaat leaders and on behalf of SQ Chowdhury in May of last year, in which we said the manner in which these individuals had been arrested for non-war crimes related matters, then shown arrested for war crimes, the failure to notify them of the nature and cause of the allegation against them, the lack of proper procedures for requesting or seeking bail, and the general failings of the legislative framework to provide a process that meets international standards of fair trial and due process indicates that they are currently being detained arbitrarily. The United Nations agreed with us and ruled that each of these individuals are being detained arbitrarily. The government didn't respond to the allegation, even though it was given an ample opportunity to do so. It has now said that it will respond, subsequent to the United Nations Working Group issuing its decision. Time will tell whether the United Nations Working Group will alter its opinion. It will probably be the first time that it has ever done so. It is unlikely, after having given the government the opportunity to respond, that it will now allow them to respond and then change its decision. We have also petitioned the United Nations Working Group on the independence of judges and prosecutors for the same reasons, by stating that the appointment process, the manner in which the trials are being run, does not meet international standards, universal standards of fair trial and due process. We expect this United Nations Working Group to issue a decision over the next few weeks. We would certainly hope that it issues a decision in advance of its upcoming Human Rights Council session in Geneva, which is due to start at the end of this month. It is particularly important because Bangladesh is a member of the Human Rights Council. That's a very, very important point that needs to be stressed, is that Bangladesh cannot turn its back on this and cannot ignore this because it is a member of the Human Rights Council and it is required to comply with the regulations and the legislative framework that the Human Rights Council sets forth. That means that the Tribunal's decision that the International Covenant is not applicable will have to be reviewed. In light of the United Nations Working Group's decision, we have petitioned on behalf of the defendants that the proceedings be stayed pending a full review of the Act, the rules and the Constitution, because the United Nations Working Group opinion clearly states that it is required to bring its procedures in line with the International Covenant. That means the United Nations has stated it is required to act with full compatibility of international standards of due process and fair trial. So let's hope that Bangladesh now addresses this problem, recognises what the United Nations has said, and puts us in a position where we can be satisfied that our clients will receive a fair trial, and that John and I and our entire team will be able to represent these individuals in a system which is fair, where there is equality of arms between the parties, and under a legislative framework that meets international standards. Thank you very much.